Hi, today we are going to talk about temporary import for re-export in the same state. And our group is conformed by Maria Carolina Alamo, Kerry Coronel, Daniel Diaz, and I, Jennifer Bueno. But what is it? Is the importation into the national custom territory, with suspensions of custom duties of certain goods destined for re-export within a determined period of time, without having undergone any modification except for the normal depreciation originated by the use made of them, and on the basis of which their disposition will be restricted. Fungible goods may be imported under this modality, nor those that cannot be fully identified. Exceptions are equipment, apparatus, and materials necessary for the production and realization of films, audiovisual works of any genre, as well as expensable accessories referred to in the Article 2.10.3.3.3 of Decree number 1080 of 2015, provided they have authorization from the Minister of Culture or the entity acting as the National Film Commission. The exception also applies to equipment, apparatus, materials, and consumables necessary for the production and realization of advertising spots, provided they have the necessary authorizations. Temporary imports for re-export in the same state may be short-term and long-term. Short-term is when the merchandise is imported for a specific purpose that determines its short permanence in the country. The maximum term of the importation will be 6 months, counting from the release of the merchandise, extendable by the customs authority for 3 more months. Long term, in the case of capital goods, and the parts and accessories necessary for the normal operation, which come in the same shipment, and the maximum term of this importation will be 5 years, counting from the release of the merchandise. It's important to know that the Special Administrative Unit of the National Tax and Customs Director, or maybe in Spanish, la DIAN, shall determine in accordance with the parameters set forth in this article the goods that may be subject to short, long-term, temporary importation. Also, in special cases, and the customs authority may grant a longer term than the maximums indicated in this article. But why? Is because when the purpose for which the imported merchandise is designated so requires. Likewise, it may allow the long-term temporary importation of accessories, parts, and spare parts that do not come in the same shipment. And for temporarily imported capital goods, as long as they are imported within the term of the importation of the capital good. In these cases, prior to the presentation of the import declaration to corresponding authorization must be obtained. Short-term temporary import declaration. The short-term temporary import declaration shall indicate the term of permanence of the merchandise in the national customs territory, and the customs duties shall be paid at the rates in force on the date of its presentation, and abstentions, and for purpose of the constitution of the warranty, if applicable. No customs duties shall be paid on the short-term temporary import declaration. The long-term temporary import declaration shall liquidate and the customs duties in United States dollars at the rates in force on the day of this presentation and expenses, and shall indicate the term of the permanence of the merchandise in the national customs territory. And the customs duties, and thus liquidated, shall be distributed in equal semi-annual installments and for the term of permanence of the merchandise in the national customs territory, and the installments and shall be paid in 2 semesters, and for which purpose they shall be converted into Colombian pesos and the exchange rate in effect for custom purpose at the time of payment.
Article 203 in modification of the term of importation. If the goods are temporarily imported for a period less than the maximum established, the declarant might extend the period initially declared only once, without exceeding the maximum established in the Article 201. For this purpose, the input of the declaration shall be amended as it's to be. In the case of long-term importation, the balance of the customs duties must be adjusted, taking into account any new quotes. In both events, the guarantee initially granted must be extended. Article 207. Long-term temporary goods where it's replaced. Where it's decided to export goods temporarily imported on a long-term basis because they were damaged, defected, or unfit the necessity for which they were imported, the goods repair or for which they were replaced shall be subject for a new declaration of temporary importation, in which the corresponding custom duty shall be raised, the amount of which shall be reduced by the quotas already cancelled for the importation of the goods export. No more than 6 months may elapse in which may be extended by a single period in duly justified cases between the day of export of the damaged goods, the defective or improper, and the loading and acceptance of the import declaration for the repair goods or the goods we may replace them. Parts of capital goods temporarily imported on a long-term basis which are damaged may be exported for repair or replacement, in which case they shall be subject of a new temporary importation declaration within the period specified for in the preceding paragraph, failing in which the guarantee shall be effective for the amount corresponding to value of the taxes of the exportation party. In this event, there will be no regulation or taxes, nor will the period of temporary importation be interrupted or suspended. Article 209. Substitution of the importer. The importer might be substituted, for which the import declaration must be modified as well as the guarantee grant, without any case of the substitution unless an extension of them or the modification of the quotes. Article 213. Document that has to be conserved. In the case of temporary importation, the declarant shall keep some documents that which are the next: commercial invoice, transport document, certificate of origin, health certificate, packing list, mandate where there is no customer endorsed, official bank payment receipt, copy of the guarantee granted, period license in the case of the capital goods.
Article 208 Modality Modification. In a temporary importation, when it's decided to leave the merchandise on the importing country, you should, before the time lapse expiration of the temporary importation, change the temporary import declaration to ordinary import or with franchise and obtain the corresponding lift or re-export the merchandise, paying, when it's necessary, the totality of the custom taxes of unpaid fees, the relevant interest, and the pertinent infraction. In the event of non-compliance with this obligation, in the case of short-term temporary imports, the goods are seized and the guarantee shall be given in the amount corresponding to the customs duties and the sanction referred to in paragraph 1.3 of Article 616 of this decree. In the administrative procedure for imposing sanctions, unless it's voluntary, legalizes the good with the payments of customs duties and the penalties cited, without there being a responsibility of payment of ransom by voluntary legalization. If the goods are seized, the legalization shall give rise to the payment of custom duties plus the corresponding redemption provided for in 8th subparagraph of paragraph 2 of Article 293 of this decree. In the case of long-term temporary imports, an administrative act shall be issued declaring the non-compliance and ordering the enforcement of the guarantee in the amount corresponding to the insolvent quotas plus interest on areas and the amount of the corresponding penalties provided for in Article 1(6) of this decree. As part of the administrative procedure for imposing sanctions, once the administrative act is enforced, a copy of it shall be forwarded to the section of customs or excise, which granted release of the initial declaration in order that the amendment to the declaration on temporary admission to ordinary importation may be made on its own initiative. Article 211 Temporary importation of goods under lease. Capital goods, their parts and accessories necessary for their normal functioning that come in the same shipment can be temporarily imported when they are subject of a lease with or without option to buy. They enter for a period for more than 6 months and settle the customs duties in force of the date of submission and acceptance of the declaration. Article 212. Substitution of goods temporarily imported under a financial lease. When it is decided to re-export a good temporarily imported under a lease to replace it with another, the replacement good shall be the subject of a new import declaration, in which the corresponding customs duty shall be paid, the amount of which shall be reduced by the quotas already cancelled for the import of the goods re-exported. The balance will be divided into the shares indicated in the new lease registered in accordance with the exchange rules, without in any case the replacement entailing an extension of the period initially declared.
Aim of the temporary import with 1. Export of the goods. 2. Ordinary import or refranchise. 3. The modification of the declaration from temporary import to ordinary import by customs authority in accordance with the terms of Article 208 of the decree. 4. The destruction of the merchandise by force majeure demonstrated before the customs authority or the destruction by denaturalization of the merchandise before the presence of the customs authority. 5. The legalization of the merchandise when it is necessary to do so. Article 215 Export. Goods temporarily imported on a long-term basis may be exported at any time during the term indicated in the import declaration, referred to in Article 203 of the decree, provided that it hasn't been detained and the declarant is up to date with the installments corresponding to the state in the national territory. Extension in the short-term temporary importation. The declarant may request a one-time extension of 3 months of the initially declared term, no less than 10 working days prior to its expiration. It doesn't exceed 9 months in accordance with the provisions of Article 201 of the decree. Authorization of longer term. When the purpose for which the goods are imported temporarily on a long-term basis requires a longer period than the maximum period established in Article 201 of the decree,
The declarant, prior to the filing of the initial declaration, shall file the respective application, giving the reason justifying the long term.